Not
for rehearing.
allowed, no.
Oh,
Y'all disbarred me on February 28, 2011.
Ms.
I
Barnes,
was never allowed to be heard, and I had a court-appointed lawyer forced on me in violation of Forever versus California.
Ms. Barnes,
You
listen
cannot
carefully.
force a court-appointed lawyer on someone.
You're not answering my question.
Silence.
Yep, this is a little old. This is from a stream I did last year from a hearing that I got a couple years ago. At minute six-ish, she gets really, really good. Here we go, guys. Buckle up.
No, this is the trick you played with moral turpitude. This was not a crime of moral turpitude, and that's why seeing John Bradley and Robert McKay did all that finagling. If you know criminal law, you cannot have a deadly weapon finding unless you show during the commission of a felony there was a use or display of a weapon. Look at the indictment. It says what the law says, felony. The game they played on February 28th of 2011, when I proved the judge had no oath of office, and John Bradley and Robert McKay did their no plus K and completely gutted the indictment. They didn't realize when they gutted the indictment on the part they couldn't prove and said it was superfluous, when it was the heart of the indictment that made the felony. The court no longer had jurisdiction. The problem is when I proved the judge had no oath of office, he got mad, revoked my bond, threw me in jail, and they forced a court-appointed lawyer on me that John Bradley got to pick. She wouldn't investigate all the complaints we filed against Alan Schreiber.
Elements of moral turpitude.
When they got it and amended the indictment, took that out, they were only, and he says it on the record, were only alleged assault by threat. That was the problem they had. When I came back and filed my motion to dismiss, you no longer have jurisdiction because an assault by threat is a Class C misdemeanor. And in fact, because the threat was reportedly, if you don't get off my property, I'm gonna kill you or something like that, her story changed every time she told it. That was the threat the woman in the pasture made. Now, that is
Blame it on the man.
Except if the allegation is that this is a criminal trespasser on a landowner's private property, Penal Code Section 9.04 and 9.41 says the landowner has the right to make a conditional trespass warning threat. There were signs up, no trespassing. If she were on my property, she would have to circumvent a security gate that had a big bold up trespassing sign. She would have to trespass.
Do we think she's going to cry? Do we see any tears in this woman's future in this hearing? That would be epic.
Because at least a dozen landowners for 4 miles are coming in trespassing. You cannot take a non-threat in that situation. It's not a Class C misdemeanor if you're alleging I'm a landowner and you're alleging she's a trespasser. It's no longer even a Class C misdemeanor. Merely exhibiting or displaying a deadly weapon when you're engaged in a non-crime doesn't make that a second-degree felony. When I filed my motion to dismiss, they knew they had a problem, but they couldn't go back to a grand jury and get a proper indictment.
Jack, she's talking about the underlying case, and we're here on motion for entry judgment, the jurisdiction of this court.
I think she's trying to respond to Mr. Gonzalez. Hold on, both of you. Mr. Gonzalez, has your question been answered?
Now, I'd love to go back to the Code Construction Act.
Yes.
And if you could just help me understand the difference between their response and your argument that there's there's two conflicts about which we use.
This is why you have to be careful with people like this.
No,
Read her response. I read it and I went, do people really think like this? Her response was that 81.077 didn't apply, that 81.078 applied. I'm like, are you kidding me? Read 81.077 and 078 together as they're written. It's very clear. You cannot do what she's doing.
Ms. Barnes, Mr. Gonzalez was asking about the 1991 legislation 4 years after the statutes you relied on, 82.078D. Are you ready to respond about 82078?
You can't retroactively apply that.
The legislature adopted that statute in 1991. Are you Do you have any contentions
You
why that
cannot
should not be applied?
You cannot disbar an attorney by claiming there was moral turpitude when there was not. That is the fraud they have been running. Just like if you look in her pleadings, she just testified to under oath, she conflates it again.
You filed briefs in the Supreme Court making that argument, and that was rejected, was it not?
No, I never want to friend it, but you know because she knows.
And then you filed
I
a
was
motion
not
for rehearing.
allowed, no.
Oh,
Y'all disbarred me on February 28, 2011.
Ms.
I
Barnes,
was never allowed to be heard, and I had a court-appointed lawyer forced on me in violation of Florida versus California.
Ms. Barnes,
You
listen
cannot
carefully.
force a court-appointed lawyer on someone.
You're not answering my question.
Silence.
My question is this: did you not file handwritten briefs in the Texas Supreme Court that are matters of record available online and in the files of the Supreme Court?
What are you
Making
talking about? I
these
have
arguments
filed writ of
that
habeas
were-
corpus appeals,
No,
these
appeals
more
from-
Ms.
specific.
Barnes,
Appeals from the
Please.
Boda decision. And the Supreme Court rejected your arguments, and you filed handwritten
Oh,
motions for
please.
rehearing, and those were rejected, were they not?
Oh, please, we're gonna hold someone in prison, no files, no access to the library, nothing. We're gonna run in and do this little underhanded crap, convince both, whoever that was, because I wasn't allowed to be there. I really liked the order that said Miss Barnes was noticed but failed to appear. Like, you know, I'm sitting in the penitentiary of a crime I didn't commit because of this type of crap going on in the practice of law that y'all won't do anything about.
The
You won't
question
do
was about the
anything about the
Supreme Court.
crap.
The question was about the Supreme Court. Did the
What?
Supreme Court not deny each of your motions for rehearing?
It is not moral turpitude. A jury would never find that was moral turpitude. They again went on her allegations, just like Jeff Rose in his opinion. That was never in the indictment. I was never indicted under 9.05. There was no allegation that the shots were fired at her. She never said that. She continues to say it. Jeff Rose says it. Why? Because the media said it. Why? Because the prosecutor put that in the media. The witness never said that. Even though she was paid over $5,500, that was never disclosed from misappropriated state funds. Even though she was taken out to my property while I was being held in the solitary confinement and tampered with. None of this disclosed to me. The fact that she had a master's degree in acting and directing, none of that was disclosed to me.
Elements.
Mr.
It's
Marqueta,
not moral
Mr. Marqueta,
turpitude.
is your
A
question been answered?
non-crime is
No,
not
but I'm
moral
satisfied.
turpitude.
Okay, thank you very
If
much.
you think it's moral turpitude,
Ms.
you
Barnes.
say it every
Ms.
forum
Barnes.
out there that tells someone, if you don't get off my property, I'm gonna kill you when you're trespassing, then that's moral turpitude. That's what you're saying. She is twisting around, just like the prosecutor had to do.
Elements. Mens rea.
There is, I briefed moral turpitude. It is not moral turpitude. Matter of fact, y'all had a lawyer in San Antonio that actually shot a process server in the back. And y'all said that wasn't moral turpitude. He gets full due process. He got full due process. From day one, I've never had due process. I didn't get to have my defense put it in trial. I didn't get to call my witnesses. I didn't get to confront the perjury on appeal. Jeff Rose again. Jeff Rose
I'm
has
so
lost
sorry.
every one of my appeals for over 5 years.
Ms. Barnes, hold on just a second. Do we have any other questions from anybody on the board?
No, Mr. Chair.
And within 4
Okay,
days of
Ms.
me filing
Ms.
a
Barnes.
motion to
Ms.
recuse,
Barnes,
he filed a retaliatory opinion.
thank you very much.
You can't deny someone due process like you are. You do not have jurisdiction.
Thank you, Ms.
You have
Barnes.
no jurisdiction, no
Please be
authority.
seated. Please be seated.
This time I just respectfully request that the board deny her motion to dismiss or transfer Bailey.
Thank you
And
very
I
much.
still renew my request to cross-examine Mr. Berry because she knows the documents she put in are fraudulent and the testimony she presented to the board was not truthful. And I have the letter from Hope, State of Texas,
Crazy
Hope
attorney.
Andrade, proving again, which she's been served many times, as have y'all.
Do
Supreme Court,
you have anything else you want to offer from an evidentiary
Yes.
standpoint?
yes,
Why
this
don't
is
you mark
not
it
a
in-
valid judgment.
Why don't you mark it and we'll take a look at it?
I'll take a look at it. Yep. Okay, the whole hearing is like that. I just gave you a snippet, and it was so hard to pick which snippet because the whole hearing is like that. I'm going to link it in the description so you can see she got disbarred and she is still fighting and screaming and yelling. And then she stands there and says, "No one heard me." Us? We all hear you. Everybody hears you, woman. You've been screaming the whole time. Thanks for coming out, guys. I'll see you again soon. Bye.